Right, and judges of the East African Court of Justice are ending their tour of duty after serving their respective tenures. The East African Court of Justice hears cases on violations of the rule of law, one of the fundamental and operational principles set out in the East African Community Treaty, established in 1999 and located in Arusha, Tanzania. The court hears cases from Burundi, Kenya, Rwanda, Uganda and Tanzania. To share with us the scorecard and milestones achieved by the court over the last 7 years, we are privileged to host His Worship Euphnalis Okubo, the current registrar of the East African Court of Justice. Honorable Euphnalis, thank you so much for joining us on Bottomlime Africa.
Thank you very much.
Great. Straight on, sir, I'd like you to talk to us about the role of this East African Court of Justice. I know it has a judicial role, but if you could quickly take us through that, Honorable Euphnalis.
Thank you. First of all, the role of East African Court of Justice is to interpret the treaty, which is the binding document of all the 6 partner states. In doing so, initially when the court was set up, it was set up with the purpose of dealing with the trade disputes, because with integration we were mainly talking about trade. But we realize we have had very many cases that are not related to trade, which are the precursor for people integrating. For example, we have had quite a number of rule of law cases, good governance cases, social justice cases, environmental cases, and even human rights, which have been very many. The reason being, you need to clear all these matters first, even matters of human rights, before you can eventually integrate. The main issues that are always cases filed upon are violation of human rights, good governance, and the rule of law. And the court has come out very strongly to protect those 3 elements in pursuance to the integration of East African community. In a nutshell, maybe that's what I can say now.
Right. Honorable Euphnalis, you brought up the issue of cases, and I'd like you to take us through the number of cases the court has filed and perhaps any prosecutions, if any. And I could mention the latest one from Kenya, where the East Africa Court of Justice awarded Kenyan politician Martha Karua about 2.7 million Kenya shillings in damages. That is for infringement of her right to a fair trial. That is one of the cases that I could point out. If you could take us through some of these cases filed and prosecutions, if any, because I must say that it looks like the visibility of the court of the East African Court of Justice is a bit low, Honorable Euphnalis.
True, the visibility of the court is a bit low, and we have been trying to do our best to increase the visibility so that the citizens of the community can make use of the court. That has been a challenge. Now, quite a number of cases have been deliberated and decided upon in our case. Not just in Kenya, but in very many, all the 6 partner states. I will mention key amongst them. About 5-6 years ago, we had a case involving Professor Peter Anyang' Nyong'o against the government of Kenya, which was relating to the election of members of EAC to the legislative arm of the community. That case was a landmark case because upon it being decided, it led to the amendment of the treaty that then created 2 divisions of the court. Nowadays we have the first instance division. If you lose in the first instance, then you have an opportunity to go to the appellate division. And that case cleared a lot of lacunas that were there concerning how partner states elect their members to EAC. I'll mention another case, a very, very recent decision involving the government of Rwanda with a famous building called UTC. UTC was a building owned by somebody which was allegedly taken over by the government without compensation. The owner of the building came to court, and this case was decided about a week ago, and he won the case. He was also awarded damages, $500,000, and the government of Rwanda is supposed to give him an account of the monies they have been collecting from that building. Now, coming back to the case of Martha Karua, maybe I would like to state clearly, first of all, that Martha Karua did not come to court to nullify the election of the governor of Kirinyaga. No. She came to court saying that the process in which her case was handled was not proper, was against the rule of law, was bad governance, and then it infringed on her right. The issue of the election of the governor was already gone, and you could not change that. So upon being heard she presented her case very well. The court was satisfied, yes, that the Supreme Court, the way it handled the whole case was wrong, and that's why she got the order she wanted, and she even got compensation. Now, the effect of this case is that every government institution within the East African community will know that whatever you do, somebody is watching, and you can be asked to account for your actions. That is how this case of Martha Karua becomes very important to the region.
All right, but then some of our viewers could be wondering how accessible the EACJ is, because I am aware that one can come directly to you. You don't have to go through, the East African communities or the member states in the EACJ. How accessible are you?
Well, first of all, many people think we are Arusha only. Yes, Arusha is the seat of the court. But to make it more accessible, we have sub-registries in every capital. For example, you in Nairobi, if you wanted to file a case, you really don't have to come to Arusha. If you go to Milimani Court, you get a sub-registry there of East African Court of Justice. And if you find your papers there, from wherever I am on my phone, there's a system we have that I will know a new case has been filed, and this is the details of the file. So that reduces the distance through which you have to come to Arusha. Secondly, we do not charge filing fee. Filing fee is free. Now, this was born out of the idea that when the community was being set up, it was meant to be a people-centered organization. So if it is a people-centered organization, it should be easy for the residents of the community to access the courts. That is why we don't charge filing fee. And even when we don't charge filing fee, we don't see vexatious matters being filed in courts. Only serious litigants come to courts. So for somebody who wants to come to court, all he needs, because most people, first of all, before they go to any court, they think of the legal cost involved. But now, if filing is free, if you have the registry next door, you don't have to come to Arusha, then all that brings the cost down, thus making access easy. Secondly, it is also possible to start a case and get a judgment without you necessarily coming to Arusha, just by filing documents. And the court will tell you are satisfied, or add this document, add this affidavit, add that, attach your evidence, we will read and give judgment, so that you don't have to spend time coming all the way to Arusha. Now we are upgrading our case management system, where if you want to file a case, you can do it from the comfort of your home, you can do it from the comfort of your office, you can do it from anywhere. And if you find that within 2 minutes of your filing, I will have that information from anywhere I am, including even on my phone. That makes access to justice very high. Secondly, our courts try to determine the matters within a very short time. An average running time of a case is about 1 year. You'll have your decision taken. I think Martha Karua's case was filed last year, and today we are done. It was not even beginning of the year. It was around mid of the year there, but today it is done.
And it's actually a good thing that you've brought that out, Honorable Yufnalis, because it was actually supposed to be my next question. On the issue of the need for permanent judges, I know we've had this discussion severally, but let's talk about having permanent judges and what this would do to aid the fact that, to aid the process of cases being had sooner, though you have already addressed that, Honorable Yufnalis.
Yes, thank you. Initially, when the court started, it didn't have a lot of cases. So they felt it was not necessary to keep judges there sitting idle. It actually took 4 years before the first case went to court. But over time, and people knowing about the existence of the court, cases have really, really increased. We have made several cases and several presentations to our Council of Ministers of the need to have the judges permanently in Arusha. Now, what happens is that they come in sessions. For example, they come 4 times in a year. That means once every 4 months. So if this month we have the first instance coming, the next month it will be the appellate division, the next month we rest, like that. Until November, that's when we have both of them together. Now, the effect of that is that it sort of delays cases a bit. Remember, some of these judges also are judges in their national judiciaries. So I have sort of a dual loyalty. He has work back home and he has work here. So like if there's a matter that is very, very urgent, And these judges have just left Arusha, they've gone back. Getting them back becomes very difficult, and somebody has to wait about two months before they come, yet maybe the matter was filed under certificate of urgency. So we have made presentations with the justifications to our ministers, telling them if we have the judges here, in fact, it is a high time that this court, now we have judges permanently sitting in Arusha. Everybody will gain. Even the partner states who are always sued themselves in court every day, they will gain because matters will be determined quickly. We even did a cost-benefit analysis of having them permanently in Arusha vis-a-vis them coming every now and then in sessions. And we find the cost difference is very, very minimal compared to the gains the court will do. So that is an issue which is being addressed, and we are also still pursuing it. I hope in the near future we are going to have judges permanently in Arusha.
Right, and we'll come back to that. But I'm aware of mobile courts within the EACJ. If you could address that and how effective perhaps they have been.
Maybe it's not mobile court as such. It is a circuit court which we did it twice. The time we came to Nairobi, I think, to deliver judgments. The other time we were in Dar es Salaam also to deliver judgments. It is always in our program, our intention has been that at least in a year, we go to one country for a month. But that has been hampered due to financial constraints. Sometimes we never get sufficient funds to be able to implement those activities. But it is something, it is in our strategic plan, it is in our annual plans, it is in our budgets, but the funds we get don't allow us to do that. We would like a situation where we say the month of September, from this date, we'll be having cases we'll conduct all our matters in Nairobi, and we have all lawyers who are flying in from wherever, come to wherever we are in Nairobi. So it is something in the pipeline.
Right. Now, a new team is coming in, Honorable Euphnalius. Let's talk about the future of the EACJ, what you would expect from them, even as the registrar of the East African Court, because by now we all know the judges are ending their tour of duty. They've come to the end of their tenure. So let's talk about what you expect from the incoming team and, of course, the future of the court as we wind up, sir.
Yes, thank you. A new team is expected as soon as we have the summit. We were supposed to have a summit on 5th of December, but unfortunately it was postponed. We are expecting to have a summit next year. Now this team, first of all, will find their interests very full, very, very full, because the outgoing team has done a lot to prepare cases that I should just go straight into hearing. Another thing which the new team will have to embrace is information technology. Throughout the COVID, we never stopped. From wherever we are, our judges were scattered all over, and staff was scattered all over, but we still continued hearing cases, dispensing justice without any hitch. That is something they'll have to embrace. The future of the court, I see it becoming a very important court, not just in East Africa, but in Africa, where even the other regions are going to copy the way we are doing things. One of the advantages that we have that many other regional courts, even Commercial Court of Justice doesn't have, is that in our court, we don't have what is called exhaustion of local remedies. Now, exhaustion of local remedies will mean you start from the Magistrates Court, maybe go to the High Court, lose, go to the Court of Appeal, lose, go to your Supreme Court, lose, then come to us. Now look at the time you will spend by the time you finish with the Court of Appeal. Look at the amount you will have spent by the time you are losing the Court of Appeal for you to come to East African Court of Justice. We don't have that. It is direct access. Many other regional courts in Africa don't have that. And even many other international courts don't have that. That gives the East African Court of Justice some uniqueness, which will make this court be a bigger and better regional court compared to the other courts in the region. Secondly, we are also improving and moving so much and encouraging arbitration. Our judges are trained arbitrators, so they don't just sit as arbitrators because they're a judge, but they are trained to be fellow arbitrators, so that if a commercial dispute comes by way of arbitration, it can still be handled well. So we don't discriminate, we don't just deal with matters of interpretation of the treaty. We also give an opportunity for businesses to come and arbitrate their issues there. More so considering that we are going to have a lot of people doing cross-border trade. Those are all commercial businesses. And remember, when an investor comes, one of the things he looks at is in the event of a dispute, how do I quickly resolve it? Because we're talking about money being tied. How quickly do you resolve it? So we have both avenues in the East African Court of Justice where they can benefit from. And I think that gives us an upper hand compared to other courts.
All right. Thank you so much, Honorable.